Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Serre, Court of Appeal for Ontario. Heard May 19th, 2020 by video conference. On appeal from the sentence imposed on May 31st, 2017 by Justice Mitch Hoffman of the Ontario Court of Justice. Reasons for decision. The appellant abandoned his conviction appeal and appeals his sentence of 6 years less credit for 26 months he spent in custody that he received after being convicted of impaired driving, dangerous driving, failing to stop while being pursued by the police, and driving while disqualified. The appellant submits that the trial judge erred by failing to fully apply Gladue principles when considering the appellant's criminal record. The appellant has a lengthy criminal record with 40 convictions, of which 20 convictions are directly or indirectly related to driving and alcohol. However, this is the first sentence for which a comprehensive Gladue report was prepared. A number of appellant's previous sentences were imposed before the enactment of Section 718.2e of the Criminal Code and the Supreme Court's decisions in the Queen in Gladue and the Queen in IP Lee. The appellant submits that Gladue principles were not properly applied in his previous sentences and that these previous sentences established an artificially high baseline for the imposition of the present sentence. He submits that the trial judge erred by failing to inquire into his previous sentences and exercise additional restraint before imposing a greater sentence on this occasion. He seeks a reduction of his sentence to 4 years and 2 months less credit for his pre-sentence custody or time served. We were advised the appellant was placed on statutory release on April 16, 2020, subject to terms seeking to ensure he refrains from alcohol use. We see no basis for interfering with the sentence imposed. The appellant does not argue that the sentence is demonstrably unfit. The trial judge carefully reviewed the Gladue report and took into account the systemic factors that contributed to its offering. He made specific reference to links between the appellant's alcohol use and events in the appellant's personal life, noting the appellant's moral blameworthiness was reduced. The step-up principle played no role in the trial judge's imposition of sentence. Rather, the trial judge stated that the paramount consideration on sentencing was the protection of other drivers and other users of the road. The Crown agrees that the victim surcharge imposed should be set aside. The appeal is allowed only to the extent of setting aside the victim surcharge imposed, and in all other respects is dismissed.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.